Morning, everyone. As Jade said, yes, I'm co-editing our sort of employment HR law newsletter, which hopefully all of you are subscribed to, and hopefully you find it helpful. I'm an associate here at Fox Williams in the employment and professional services teams. So I'm going to kick off with the start of for 10 before handing back to Jane on the question of where does returning to the office fit in with the overall Spring 2021 roadmap from the government, which was unveiled on 22nd of February. So a month and a little bit more has gone by, and we're still just about on schedule, I think, despite news of some lumps in the road on vaccine rollout and international travel, I believe, has just been pushed back until at least July. Aside from that, the show goes on in terms of the next 3 or 4 months. So I think most importantly and most pressingly is the stay-at-home law will lift on 29th of March. So on Monday, that's technically a lifting of lockdown, but it's quite restricted in terms of its scope. You're allowed to leave home with others outdoors in groups of 6, outdoor sports and recreation, but the guidance will remain and does remain to work from home where possible and to minimize any travel. So in terms of what that means for returning to the office, not much at all. Further movements then may have more of a practical effect, simply because with bits of the economy opening up, like non-essential retail, the injunction to stay at home, work from home where possible, is obviously not going to be applicable to quite so many, those in retail and of course hospitality, hairdressers, and so on. So that's back to work for many. In terms of those who work in the office environment and who still can work from home, it's a bit of a movable feast, really. There will be a review before the end of stage 4, which is the 21st of June. So sort of quite in-depth review by the government in May or early June about things like social distancing measures, but also the working from home guidance. So it's quite dependent on that as to where the time frame for return to the office ends up. Of course, as Jane will go on to discuss in the next slides, you can, to an extent, return to the office where lawful, but there's certainly a greater risk of doing so now as opposed to post-June or whatever the May or June review says about it. I think one sort of signal is the fact that the furlough scheme is not due to end until 30th of September, albeit employers will start having to share the burden from July, end of July, and in August. So that certainly suggests that there's not going to be a big bang from 21st of June or thereabouts in terms of rushing back to normal, but certainly relaxation over the coming months. So I'll now pass on to Jane to talk about what the law is currently under the lockdown regulations.
Yes, so in talking to you about this topic, I'm not entirely sure, of course, what your current understanding is, but just in case there is a lot of confusion out there, a few points from us. First of all, government guidance is not the same thing as the law, and there's been a lot of comment in the media about this because there's extensive guidance, but it's not necessarily underpinned by law, and you're really only in deep trouble in terms of a criminal offence if you breach the law rather than the non-binding guidance. The law is contained in the Health Protection Coronavirus Restrictions, All Tiers, England Regulations 2020, and they're found on the gov.uk coronavirus legislation website. And it's a breach of this law. A breach of this law without reasonable excuse is a criminal offence punishable by a fine. And that offence can be committed by corporate entities and by officers of corporate entities. So it's an offence that can be committed by employers and officers of employers. And those regulations currently prohibit leaving home and indoor gatherings without reasonable excuse. Now, of course, those restrictions are subject to lots and lots of exceptions, which we're all operating within at the moment. But the key exception for employers is a reasonable excuse is where leaving home or attending a gathering is reasonably necessary for work purposes. So that's the key test. As Ed has mentioned, there is a gradual easing of restrictions, and the law changes on leaving home on the 29th of March. But our understanding is that the prohibition on gatherings in the coronavirus regulations will continue for some time. Now, that will all be subject to review, and those regulations that I've referred to are regularly updated. So we're not completely sure, but our working assumption at the moment is that the prohibition on gatherings, subject to an ever increasing number of exceptions, will remain in place for a while. So on that assumption, we need to look at the next slide and work out what is reasonably necessary for work purposes. And frustratingly or helpfully, depending upon your point of view, there isn't actually a definition in the regulations themselves of what is reasonably necessary for work purposes. And in the office, we are being asked by quite a few clients as to what exactly this means, especially as everyone looks to bring people back into the office gradually. So we're trying to be as helpful as possible, but at the end of the day, it does fall to the employer to determine what is reasonably necessary in the context of their own business and their own staff, and also to defend that decision if ever it were to be questioned by law enforcement. The government guidance, which is voluminous in many areas, is very, very sparse indeed on office working. And at the moment, it just says, and this is non-legally binding government guidance, that everyone who can work from home should continue to work from home until at least the 21st of June, hopefully the end of the road. But, and you don't really need me to say this, I think it's getting increasingly difficult, both for business and for staff, to continue the mass stay-at-home movement, if I can call it that. And it's getting very difficult for lots of different reasons. And so I think there is a real sort of momentum to try and come out of lockdown and get back to the office. And what we need to consider today is what scope is there for you to empower that or to compel that. So on the next slide, we have a little bit of a look at what might be the test for necessary to be in the office. In 2020, the government guidance was actually a little bit more detailed and helpful than it is now, because it contemplated that reasons for working in the office could relate to individual members of staff. So individual member of staff's health and well-being, including their mental health, and the inability of individuals to work properly from home, such as their environment, their equipment, when the kids were at home, having children at home, and so on and so forth. So those are all person specific. There was also a category of reasons relating to the business, where the business needed people in for operational requirements and for compliance and regulatory requirements and so on and so forth. And of course, many businesses have had essential people working in offices for those types of reasons, some throughout the lockdown. Those reasons are still potentially quite valid now, even though they're not in the guidance. It's a question of what is reasonably necessary. And it seems to us that after a whole year of lockdown, from a business and an individual staff viewpoint, some of these reasons may be becoming quite compelling, and it may be changing. So it may be that a year ago it was okay to have some people at home, and 1 year on it's definitely not. So our advice at the moment, pre-June, is to assess each situation and each person on an individual basis. And if you think it is reasonably necessary for somebody to be in the office, document why attendance is necessary. And the other thing, of course, is to keep an eye on government guidance and to keep an eye on the regulations, because in this area, things are changing all the time. So if I can have the next slide. Everyone is talking about new normal at the moment. And what they're talking about mainly is the balance between home and work. How many days are people going to be in the office? How many days at home? What about flexible working? Is this way of communicating going to become the norm for meetings, and so on and so forth? But there's one thing we'd like you to think about, which is the health and safety aspects of new normal. Employers are required to take all reasonably practical steps to safeguard employees' health and safety at work. And as we've advised before in HR law, and as I'm sure all of you are aware, this involves conducting risk assessments relating to COVID risks, but also other health risks, and the requirement on employers to develop health and safety policies to manage health risks at work, and also in the context in particular of COVID, traveling to work. If the employer doesn't discharge its duties properly, then the employer may have potential liabilities to staff for negligence. And in this area as well, there's also the possibility of criminal offences in extreme cases. As to what is a reasonable standard of care, the best guidance we think, and we have advised consistently, is to follow government guidance on how workplaces should be set up to manage the COVID risks. Hence, everybody having 2-meter signs on the floor, hand sanitizers, one-way systems, temperature checks at the door, and screens, and so on and so forth, that everybody's been sort of working on this for the past year or so, insofar as we've been bringing people back and having people actually working in the office. All of that continues, and everyone is best advised to follow the government guidance on all of that, which will, we believe, change over time. So it's not my place to tell you where to put your hand sanitizers, but what we have developed in 2020 was our 10-step guide to opening an office safely from a legal and compliance viewpoint. And we're going to shortly update that and email it out on the HR law mailing list to all of our subscribers. And we're going to update it to take account of testing and vaccination, etc. But that guide is intended to be a guide to legal compliance, so that you can demonstrate that you are compliant with all the health and safety requirements and that you document it properly. So we hope that's been helpful for everybody. What's new since we did the guide last year is the availability of vaccines and rapid lateral flow tests. So we're going to put a little bit of emphasis on those two new items in this particular webinar, and I'm sure that's the topic that everyone is focused on at the moment. But just before we get there, I just want to take the long view, and if I can have the next slide, we'll be looking at just the longer term. So just a few thoughts from me, as well as considering the new patterns of work post-lockdown, new normal. I think there's a new normal for managing health and safety at work that draws upon everything that we've learned in the pandemic. And one of the things, of course, that we've learned is that health and safety policies and risk assessments should not be formulaic documents, tick box exercises, gathering dust at the bottom of a drawer in the facilities office. They need to be much more important living documents and processes than they have been in the past. COVID-19 and its variants will require management for a long time to come. And government is obviously very focused on this at the moment, and will be issuing guidance to all of us as to what we need to do in that new normal in the future. But at our level, at the employer level, we need to think about what our policies and procedures will be in the longer term. There are, of course, other infectious diseases, and there may be new ones in the future. And so what will employers be doing in order to manage infectious disease risks in the future? And one of the thoughts that's occurred to me is that it might be time to end the winter misery of office workers being constantly ill from bacterial and virus infections caught at work or traveling to work. It's time potentially to end presenteeism when ill. No more heroic staggering in order to be at your desk and do your bit. The new mantra could be, don't bring your germs to work. I myself have felt, I've been lucky not to catch COVID. That's very fortunate for me. I know loads of people have, probably lots of you listening. But in the absence of COVID, I felt better without the normal run of flu and sinus infections and colds and everything else. And I just wonder whether in future employers need to think harder about how to safeguard employees from various infectious diseases and health and safety risks more generally. So I think it's time for some fresh thinking about health risks and how to manage them, and to introduce new policies to counteract the risks that have been identified. And of course, as that thinking proceeds and policies are implemented, it's a very good idea, and indeed it's a legal requirement to consult with employees. So I hope that's a few helpful thoughts about the future. Returning to the present and testing and vaccination. So we look now at testing. Something that is now available for employers is free testing. As you'll all be aware, there are two main types of tests available. The PCR tests, where they are the most reliable, where the results are available from the lab 24 to 48 hours later. And there are the very useful for employers rapid lateral flow tests, where you get the results in 30 minutes. Slightly less sensitive, but still extremely useful and pretty reliable. So the government have introduced a scheme for free lateral flow tests where employees cannot work from home. So that is not really available to all the people who have to stay at home under the guidance to stay at home for the time being, but it is available for the people who have to work in the office where it's necessary. We've discussed that. There's a process for registering for lateral flow test kits. It's easily found on the web before the 31st of March. Kits are available to the 30th of June, 2 per employee per week. So this introduces the possibility of a new way of managing COVID risk as part of health and safety risk management. And we have been discussing amongst ourselves exactly how this would work in our own office. We're on the 5th and 6th floors in a lovely office in Finsbury Square when we can actually get into it. And we've been wondering about whether or not we would do it ourselves and have our own lateral flow testing station down on the ground floor. So you can't go up to the working floor until you've been there, done your test, waited half an hour, maybe walk around Finsbury Square outside and then back in the door half an hour later. Or is that a sensible thing to do? For heaven's sake, don't go into a pret and infect everyone downstairs in there. How about third-party providers? The very good healthcare companies supporting the corporate world, such as Nuffield, HCA, Bupa, etc. They're providing test services for fees. They may be useful for employers to help support a testing policy. And there are also local authority providers. And I read about something being set up in Canary Wharf this week. Another approach is to send test kits home to employees and rely upon them to do their own home testing before they set off for work. So there's lots to think about there, and I'm sure employers will come up with lots of different ways of building testing into their health and safety management policies, but it's a really helpful new tool to have available. One thing we've picked up is that you can ask staff to take a test and then go straight up to the working floor. According to the guidance, they don't have to sit in a holding pen with everybody else, but obviously that's slightly self-defeating, because if the test comes back positive and they've gone up, they've now been in close contact with lots of other workers, and that leads to the possibility of the office having to be cleared again because of a positive test result and the need for people to isolate. So that doesn't sound like a great idea to me. And obviously the testing policy may be applicable also to contractors and visitors. So hopefully a few helpful reflections on testing before Ed tackles the red hot topic of vaccinations, even in the media this morning. Ed, can we go into a pub if we're not being vaccinated?
Well, to paraphrase the Prime Minister, I think that may be something for the individual publicans or the landlords. We shall see. I mean, Jess, if you could flick on the slides to vaccinations. Thanks. So yes, hot topic, big question, tricky question. Something we've done some thinking around, as have many others, and we've said our thoughts in a recent HRLaw newsletter, which is online, despite the fact that this is quite a moving target. So as we mentioned, there's recent news of government plans to make vaccines compulsory for care home staff, potentially frontline staff, particularly in light of some quite surprising statistics suggesting a degree of hesitancy among care home staff. So for our purposes, requiring staff to be vaccinated is unlikely to be lawful, simply as an instruction you give to employees. in that it's not within the scope of what's contemplated by the employment contract or within the employer's right to issue instructions, particularly while it's not compulsory for even frontline workers, at least not yet. That's not to say it's not unprecedented. There was regulatory professional requirements for doctors to be vaccinated against hepatitis, for example. You may have more luck in terms of requiring it as a term of the contract for new employees as part of the contractual offer, but there are still many risks with doing that. So what about a slightly less draconian approach, which is, can we make vaccines a condition for returning to the office? You're working from home, but people are sort of slowly migrating back towards the office. Can you impose a no vaccine, no entry policy? Employers who want to do this, I think, have got a fair point. They have their health and safety duties to look at the greater uptake of vaccine amongst the staff, given that we know it does have a reduction on transmissibility, lowers the prospect of outbreaks. And it's particularly important for those who have vulnerable staff or customers, particularly those in healthcare settings, but not only. And also employers, I think, would argue that they need to know the extent to which their workforce is vaccinated, so as to assess the health and safety risks to the physical premises. And of course, the other thing that this approach has going for it is that it's practically workable, in that you can, without too much difficulty, refuse entry essentially into the office by use of electronic passes and so on. That said, it's certainly open to challenge and is risky. You've got potential breach of contract claims. An employee might say, well, my place of work is, as stated in the contract, the office, and it doesn't say anything about needing a jab. If the employer wants to exclude them from the office, then you may well have a potential constructive dismissal argument there. There's also issues with discrimination, to an extent direct, but particularly for those who have a condition amounting to a disability, which means that you can't necessarily get the vaccine at all. And indirect discrimination, for example, most immediately is the fact that those of a certain age, those particularly under 50 at the moment, but the threshold is going down, can't get the vaccine. So there is discrimination there, and there's also data showing differences in uptakes among different ethnicities, religions, and so on. So irrespective of the sort of causes of those disparities, they exist. So you'd be looking at needing to justify the approach. There's also a whole raft of data privacy issues. This week, we've fortunately just got new guidance from the ICO on the data protection requirements. It's confirmed its view that whether or not you're vaccinated is a special category information under the GDPR, and therefore subject to further safeguards, which means there's more paperwork that needs to be in place before processing is lawful. You need the sort of standard lawful basis to process under Article 6, such as legitimate interests, and also special category processing under Article 9. There is an employment condition which is probably available in this case. Express consent, probably not, because of the nature of the employment relationship, but there's other paperwork that needs to go into that as well. Appropriate policy document, essentially setting out additional safeguards and sort of express explanation of the basis for processing that data, and a revised data privacy notice for employees saying that you're processing it and what their rights are. Because of all that, there's certainly a push towards perhaps opting for a more voluntary approach, perhaps asking for evidence but not requiring it, or even saying we want employees to be vaccinated but won't ask whether or not that is the case. I think the approach depends on the risks and how you assess them from a health and safety basis, and then you take it from there. So that's a whistle-stop tour through the vaccination issues, of which there are many, and it's somewhat of a moving target, but we'll certainly keep it under review. Now, going back to some of the risks that Jane has referred to already, what is the risk of saying to all of your staff back at your desks for 9 a.m. Monday, please, no exceptions? Well, there are a number, particularly if you want to make that instruction sooner rather than later. The sooner you return, the more risks there is, all other things being equal. Health and safety measures to think about. James already covered those. If you said that everyone should be back all at once, then that's obviously a much greater risk. In terms of compliance, risk assessments need to be carried out, circulated to staff. In terms of issuing that instruction, what are the specific legal risks? Well, though the employment contract might well say your place of work is the office, so please come in tomorrow, that's going to be constrained a bit by implied terms. So there's quite a lot of case law on mobility clauses whereby the employer has a power to relocate an employee, but that's not can't be exercised necessarily on in a way that is overly harsh or draconian or demands moving overnight or requires significant expenditure from the employee. So there'd be an analogous argument here that you can't make a sort of knee-jerk instruction overnight. Otherwise, that may well be a breach of the implied term of trust and confidence, and you may well be open to constructive dismissal arguments. There's also potential express dismissal issues if you wanted to take disciplinary action for those who refused. Possible to dismiss fairly, but many risks in doing so, particularly if you don't follow a relatively measured procedure. So a number of risks. And then, of course, if the refusal is based on health and safety concerns, then you might be looking at automatic unfair dismissal. So plenty of risk. And then lastly, discrimination. You've got perhaps, as with vaccines, almost the direct issues like those under disabilities, making them vulnerable, but also indirect issues. If you've got those with childcare responsibilities, then they can't necessarily arrange to return to the office overnight. So I think in view of all those risks, the key messages would be take it slow, sort of adopt the same attitude as the roadmap from the government itself, slow and cautious, start voluntary, and of course, risk assess, consult with employees, and if any have issues with the proposed course of action, do listen to individual objections and consider the basis for those objections. So moving quickly on now to holidays, another big topic, something we've written about, as Jane has mentioned, big issue, and it'll probably become bigger over the coming months. Perhaps now not until July, seeing as that's when international travel may or may not return, but staycations as well. So just to recap, carrying over holiday, what are the rules? The general rule is that you may not, but there are, of course, exceptions in law for maternity leave or long-term sickness, whereby the employee couldn't take holiday. There's also an ability for employers to permit to a narrow extent. Since March 2020, the new limited exception for COVID-19, you can carry over holiday which is unused, into the next holiday year if it's not reasonably practicable to take leave as a result of the effects of coronavirus, including on the worker, him or herself, his or her employer, and or the wider economy or society. So that's obviously, most obviously, would be your being ill yourself, or having caring responsibilities, or shielding, things of that nature. Simply unable to go to your favorite holiday destination in Marbella, we think is not a good reason, and would not give a statutory right to carry over your holiday to a time when you may be able to. In terms of employers allowing carryover, quite often we would see pre-pandemic 5 days to be carried over. That's the sort of contractual amount. As a special dispensation, you might have more now, provided that it's used shortly after year end. Difficulty with that, of course, is trying to coordinate everyone who has this extra carried over holiday, which they need to take, say, within the first 3 months of the new holiday year. So practicalities to think about there. You need to sort of keep quite a close eye on plans, and maybe keep a departmental spreadsheet to make sure that you've got full service coverage for your clients, and that not too many employees are going to be off at the same time. So given that we're not looking at international travel until July, what can we do to clear the backlog? Well, employees can be required to use up annual leave if you give them sufficient notice. That notice is twice the amount of notice as the intended period of leave. So if you want them to take 5 days of leave, you need to give 10 days advance notice. And of course, actively encourage employees to take annual leave now and pre-pandemic. It's a health and safety statute, and people should be encouraged to use it. Cancelling holiday if your destination has been added to the red list and you can no longer go. Employees can cancel planned holiday, and we don't believe there's an ability for employers to say that's not allowed and it must be taken. But of course you can, if there's sufficient notice, require them to take it using the double notice rule. Self-isolation and quarantine, obviously employees in that situation, you can't require them to come to work. That is a criminal offence. If they can't work from home, then you might have to think about them taking more holiday or agreeing unpaid leave. Lastly, reminder on furloughed staff, they can be required to take holiday in the normal way, but any holiday taken is payable at the full rate and not the government's 80% of salary rate. So normal salary for that. Now I'm going to hand back to Jane for a very quick run through some of the likely scenarios you might well come across in the next few months. Back to you, Jane.
Just looking ahead for the next few months, for the employee relations specialist amongst you, I just could see so many issues over the horizon, involving all of the issues that Ed has just mentioned and the health and safety considerations. We could have the old normal purist, desperate to return. His place of work is Canary Wharf. He wants to get back. He doesn't really want to do 2 days in the office and 3 at home, and he wants all his team back. What do you do about that one? Then we have the country dweller, nicely ensconced in the country, nice big house, new house, children established. The commute is a pain, would like to stay put, doesn't really want to appear in the office very much, even in a leadership role. Then we might have the clinically extremely vulnerable, used to be working from home on a basis of medical advice, but no longer advised to shield for the 1st of April, no sick pay. Extra precautions advised, but not legally binding. Such a person may continue to be furloughed. How to manage the health and safety risks around an employee with special health conditions with COVID still in circulation. You're probably sitting here thinking, well, this is all very well. Why aren't you giving us the answers? Well, it's pretty tricky, all of this. Just flagging up what's likely to be down the line. We'll have the flexible workers putting in their requests under the pre-existing rules as to the time they want to spend working from home because of childcare and other caring responsibilities. How are those to be dealt with in new normal? The rules will be different from pre-COVID. What's the policy the employer will apply in relation to requests to vary working hours and place of work? And then finally, the beach worker. He's been ensconced in Barbados for the past year because Barbados is pretty friendly to everyone, working happily there. He's given you all sorts of issues relating to immigration, tax, social security, and you actually would like to get him back into the UK, but there's not much enthusiasm, especially since he's got a new girlfriend over there. So what do you do about him?